Hey, everybody. I'm live. Tiffany Weber with Thomas & Weber, real estate attorney. We've got 3 offices, Mooresville, Denver, and Huntersville. I'm going to do all my disclaimers up front so we can dive right into the good stuff. Today, I'm talking about who killed the deal. These are real scenarios that we've encountered, most of them over the last couple months, but this year, deals that just couldn't get over the finish line. And we're going to talk about what could have been done differently so that the transactions could have closed, or worst case, you don't get into a listing that maybe you shouldn't have taken, or something that is just not going to be able to close. And how do you find that out before you're in too deep? This is, yes, I'm an attorney. I'm not your attorney unless we have a written engagement agreement and fees paid and all that good stuff. So this is for information only. I'm not giving legal advice, but it is education that could help you moving forward as you're assessing deals and trying to get stuff over the finish line to close. So let's dive in. Who killed the deal? Like I said, we're just going to get right to it. Why does it matter to do kind of these postmortems of where it all went wrong? And it's so that you don't repeat the same thing over again. If there's something that could have been avoided, looking at these transactions that have fallen apart, yeah, it's painful. Nobody really enjoys considering where things went wrong and why. It's just not pleasant. But if you can save yourself some trouble down the road, that's why we're doing this. I'm trying to give you some tips to look at and things that you can dig into before. The first thing is always these dang marital interests. It's not, this is not something that happens across the country. So as we have people moving here, the state that they come from doesn't have this, and they think we're crazy or that we're making it up. But in North Carolina, there is a marital interest. And even if you acquire property before marriage, some of you might be watching this and thinking, oh, this is so basic. We get this question multiple times a week. So if you feel that this is basic, then you are kind of way ahead of the game, because we get this question all the time. Even if you buy property before you're married and your spouse is not on the deed, if you get married after that, your spouse acquires something called a marital interest. And if you're going to sell the property, your spouse has to sign everything to sell the property. A marital interest is not the same as property ownership. It is the right to share in your spouse's estate. If you've ever heard that you can't disinherit your spouse, that's why, because of this marital interest. And, the only way to get rid of a marital interest is to have a contract between spouses. And there's 5 different types of contracts that could work. A deed, getting rid of the marital interest. No, don't pull it off the internet, because North Carolina requires a very specific language. We'll see these DIY or self-help deeds to try to get rid of the marital interest, and it doesn't do anything. It's a spouse giving up, property rights to a property that they never actually owned and still retaining their marital interest. Or some family law practitioners won't include the proper language as people are going through a separation. So we have to go back and get all of the right language. So if you've got, a couple that's trying to get rid of the marital interest, caution them, please don't pull it off the internet. It's almost certainly not going to have the sufficient language to do what you want to do. But a deed is one of those things, a free trader, prenuptial agreement, postnuptial agreement, or a separation agreement. All of those things have to be recorded with the Register of Deeds. And think about those documents that I just listed. Other than a deed or a free trader, a prenup, postnup, separation agreement, those can be pretty juicy, and you may not want the full contents recorded. So, you could have a memorandum of that document recorded, but it still has to have all of the important stuff laid out. So this is always, run it by the real estate attorney if you're trying to figure out if you've got what you need for the transaction. Now, when it comes to spouses signing, if they're going to have to sign at closing to get rid of their marital interest and for clear title to convey, let's back it up a little bit. They should also sign the contract. They should also sign the listing agreement. When we get to our scenarios, it will become really clear why. Because if you've got a spouse that didn't sign all of that stuff, and then you get to the closing table and they won't sign anything, then you're going to have a fight on your hands for seller breach of contract. So we also do sometimes see, maybe sellers who are the only ones on the deed and they're going through kind of a messy breakup and they don't tell you that they got married after they acquired the property. Just dig. That's what I'd recommend is making sure that you've got the correct marital status of the property owners up front and helping them understand up front, yes, your spouse has to sign unless you've got one of these documents with the sufficient language making it so they don't have to. And more times than not, they don't have that. So it's a safer thing to say, yes, your spouse is going to have to sign. Next up, let's talk about heirs. This is a basis for a lot of our deals that fell apart, heirs and inheritance issues. So here's the thing. With heirs, a lot of this stuff you may not find out without a title search. And you're going to think, well, I guess we're not going to know until we get under contract. You can get a title examination anytime for any reason. Those are public records. And if there is a question as to whether you know everybody that needs to sign or who actually owns the property because of different, probates and people passing away through the years, you can find that out up front by getting a title search before you start marketing the property. Yes, it is an expense. There's, no denying that. But knowing that up front and then perhaps maybe saying no to taking a listing because you can't get it over the finish line, that $250 to $400 might be the best money that you spent as part of that transaction. But where we run into the most issues is when there's no will and someone has passed away. There is no will. So, they've got 6 kids that all inherit as tenants in common. Tenants in common means that if you pass away, your heirs get the property. So of those 6 kids, you got 1 or 2 of them that pass away, and now you own it with, the brothers and sisters and then the, grandkids. And it can go on and on and on, as you can see. It keeps making when you're drawing out family trees, we had one earlier this year that was probably like 65 heirs deep. And the people involved decided, we're not actually going to touch this. I don't think we can get this through. Just because you had to keep going through the family tree and determine you really only own like a 1/65 of this property, and it's going to be really difficult to get all those people on the same page to sell. Then you also have the issue of, okay, what if you're estranged from one of the heirs and you don't know where they are? You don't know if they have children. You don't know any of that. So you can't locate the heirs, or there might be unknown heirs. And then sometimes you might have heirs that are incarcerated, which is another level of complexity. So if you're finding that out after you're already under contract with the buyer and the title search is revealing these things, or, we've got people that have a share in the property that were never on your radar, and then you can run into issues actually being able to, fulfill your end of the contract. So yes, this is mostly, on the seller side. You don't really have heir issues on the buy side. All right, next let's talk about encroachments. So encroachments, these are just, some sort of structure. It could be a fence, it could be a shed, it could be a retaining wall, is on property that doesn't belong to the person who owns that structure. So you've got a fence, but you put it on your neighbor's property. It was a little too far over the line. That's an encroachment. This is hopefully going to continue to get better, but the way our old contract read versus how the new contract read, there were some important changes in 2023 to address all of these, like encroachment disputes. The contract used to just say, you got to provide good title, clear, marketable title, insurable title. So basically any defect of title would be a failure to deliver good title. Now the contract says you got to deliver good title free of material encumbrances. That wasn't there before. And material encumbrances are things that, either significantly affect the value, or you knew that the the buyer had a very specific use, or you knew what they were going to use it for, and this encroachment makes it so they can't do that. So material means like if this was known about, if this is a true thing, then it makes it so that the parties didn't want to do the deal. The reason that language was added is because there were so many deals blowing up over very slight fence encroachments. Like, okay, maybe it encroaches by 2.5 inches in this back corner. Reasonable people don't really care about that, but most of the time it was a buyer who wanted out of the deal for some other reason, and they kind of got lucky that there was an encroachment because it was just an across the board like title defect. Whether it was a big one or not, it was a title defect, and if the seller couldn't cure it, then they could get out of the contract. Not the case anymore. So if you weren't aware of that change and you've got a buyer that's like, well, the fence is over, if that's not material, that's not a breach of contract by the seller. And questions over whether something is material or not, that's called in the law a question of fact, things that lawyers nerd out over. And you've got questions of fact that get resolved by judges and juries. You don't want to be in a fight over whether something is material or not. So the hope is that you resolve this before we get to having to argue buyer and seller side whether something is material. Now, the contract does still require that material encroachments have to be addressed. So, if it is, your house is built over the line, that's material. And there could be other things that come up that could be material, but there's still a requirement within the contract that you resolve any material encumbrances. So, surveys, if the seller has a survey looking at that before you put the property on the market, and if you're on the buyer side, encouraging buyers to get surveys. There's very rare occasions where a real estate attorney wouldn't tell a buyer to get a survey. Maybe that's when it's just recently platted, new construction, because maybe the builder had to get like the as-built survey. But very rare, townhomes, condos, you're not really getting surveys for those usually. But in almost all cases, we're going to recommend a survey because things change over time. The seller put up a fence and they were pretty sure, that it was in the right place, and they used the information they had, maybe even an older survey in their possession, but the fence company didn't put it in the right place. The retaining walls, etc., making sure that they're where they should be and not encroaching onto a neighbor. So that's one of the biggest reasons why we encourage buyers to get surveys, even if they're like, well, the property lines haven't changed. Yeah, they probably, the property lines haven't changed, but the structures on the property, where are they located in relation to those property lines? All right, let's get into some case studies. Let's talk about these are the real scenarios that we were dealing with, or have been called in to advise on. So of course I can't tell you all the juicy things. I've got to keep it to the point where you can't search on the internet and figure out who I'm talking about. So I'm going to keep it kind of vague, but I'm going to give you enough that you've probably encountered something like this before. So going back to marital interest, we had the seller. He bought this house while he was single. He got married after. He tried to sell without the wife signing, and that was partially because his agent told him that hey, you bought it without her. She's not on the deed. She doesn't have to sign anything. So he got that in his head from the very beginning. She doesn't have anything to do with this. She's not signing anything. And the thing is, they weren't like on the outs. They weren't getting divorced. It's just that was, in his mind, his separate property. She had nothing to do with it. She wasn't entitled to any part of it. But, that pesky North Carolina marital interest. So she, once they got to the point where he understood, okay, I'm not going to be able to sell this without her signature, she said, well, you've told me and told me and told me I have nothing to do with this. And now suddenly you're telling me I do? No, I'm not signing anything. I didn't sign this contract. I never agreed to list the property, all of this. So she just flat out refused and said, I'm not signing any pieces of paper related to this. So the buyers, they really wanted the property. They weren't really going to settle for like, okay, well, you're in breach, give me all my money back and I'll move on. No, they wanted this property. So they were using the North Carolina standard offer to purchase. Specific performance is a remedy within our standard offer to purchase. And if you're not familiar or it's been a while since you've thought about specific performance, that's when you go to court, you file a lawsuit, and you ask the judge for the relief of make the other party do what they already agreed in writing that they would do. So this seller told me he was going to sell me this property for this price, make him do that. So that they went through with suing the seller for specific performance. That ended up settling out of court. They did close the property, I think, because the cost just kept creeping up and up and up. But yeah, I mean, it was within the buyer's rights to do that. Now, of course, the way to avoid that was up front, the agent not telling the seller that the spouse didn't need to sign. That could have been set up front. And if you've got, at that point, when you're taking a listing and then you find out the wife's not willing to sign, well, you've just saved a whole long, drawn out legal battle. So that's something that could have been discovered up front. Now, next, let's talk about heirs. Heirs. This is one of those where, like, family land is probably where you most often see it, where we are around the lake, that this happens all the time. The families had the land for 80 years. Nobody ever had a will. There were no deeds prepared at any point. It's just grandma and grandpa died and gave it to their kids, and their kids died and gave it to their kids, and so on and so forth. So there was, this property that this one wasn't, overly complicated. There were, I think, 8 heirs, some combination of, the children of the original owners and children of, the grandchildren, because some of the siblings had passed away. Now, this one got almost to closing, and as part of the title search, we didn't do this closing. Well, it didn't close. But we were, requested to advise on the situation after, because the deal was falling apart. The closing attorney was doing the title search and was like, not everybody signed this contract. There's 2 more heirs that you're forgetting about, because one of the sisters had just passed and her 2 children now own the property with all of the others. And one of those people were in jail. And that alone isn't a deal stopper. But when that person that is in jail refuses to sign anything unless there's some exorbitant amount of money paid that was well beyond even the value of the property, that is where it becomes an issue. So they were able to find the incarcerated individual. A lot of times, if you've ever dealt with that, you'll go through the warden and the administrative staff at wherever the person is incarcerated will help deal with getting the paperwork signed and notarized and returned. So yeah, they can still convey property, but once this person found out, they saw an opportunity to, what they believed, make a lot of money, and so they refused to sign. So this buyer instead of specific performance, they went the breach of contract way. They wanted to get their money back for, inspections. They wanted all their earnest money and due diligence, any of their damages. So they went that way and were able to get their money returned. But what the sellers still have to deal with is they can't sell this property because you've got people that are refusing to sign. So they're still dealing with the, do we have to have a partition action? Are we going to have to get a court to step in to tell us whether or not we can actually sell this property, and force the one that doesn't want to sell, force them to sell? Because yes, a court can do that. If the people can't agree, the court can step in and say, no, we are doing this, and we'll do this in an orderly way. But if you guys can't agree, I'll make you agree. Now, the next one, encroachment. This was one where it wasn't the house itself, but it was, a separate garage. And the garage was built probably about 6 feet over the property line. So thank goodness the buyer got a survey so that they could find this. It's questionable whether the seller realized it or not. The garage was there before, like when they bought, and they didn't get a survey when they bought. So it's really at this point anybody's guess whether they knew and didn't say, or if they found out when the buyer got their survey. But the garage was over the line quite a bit. And then, like here, the buyer's lender, of course, the buyer's lender required a resolution, but so did we. We can't close. That's a significant title defect. So what we proposed is, all right, we can try to get an encroachment agreement. It's a pretty significant encroachment agreement. Maybe the seller could come up with some sort of, boundary line agreement where, okay, I will buy from you this, whatever is encroaching. And really what you're looking at is not just where the garage ends. You've got setback violations too. Because this isn't just some like shed where you could maybe get away with it being in the setback because you could just pick it up and move it if the county came by. No, like this was a legit garage. So you'd have to really buy enough so that you wouldn't be violating the setbacks if you want to be able to have insurable title and marketable title. And, this was just not working out. The neighbor was not having any of it. They're kind of like, I'm not going to make you move the garage, but I'm not signing anything. I'm not giving you anything. Like, it can stay there. I'm not going to make you tear it down, but no, leave me out of this. So, the buyer, this was one going back to specific performance. The buyer wanted to push to force the seller to sell the property at the price with clear title. But they knew that maybe wouldn't work out. So their approach was, all right, well, number one, we request specific performance. In the alternative, if we can't get that, then we want our money back. We want our damages, et cetera, and we want our attorney's fees. So the seller, I wrote neighbor in here, but I meant seller. The seller is trying to say, well, we should have a prescriptive easement, or we shouldn't have to move it. We shouldn't have to get an encroachment. We shouldn't have to do anything because it's been here, however long. But this is still in the very early stages, so they haven't settled. This hasn't even gone to a hearing on a motion to dismiss or anything. It's just the initial filings. So that one, I hope, gets worked out. It is quite messy, but you want to talk about a material encroachment, a building being, 6 feet over the line. Yeah, that's pretty significant. I'd seen some of the questions coming in. No questions? Okay, if you have questions, I thought I saw a question about encroachments.
No.
I imagine that. It's probably the one that I get all the time. Yeah, ask your questions. So what I didn't want to do is just talk at you the whole time, because a lot of times these are like complex scenarios and people want to say, well, what if this or what if that? So it's your time now. Tell me what you want to know. Oh, there's one. What happens in a partition action?
Where is your presentation done? You had preventative measures.
Oh, yeah, I kind of talked about that at first. Ryan is helping me off camera. And by helping, I mean running this entire thing so that I can just talk to you. The preventative measures, title searches, surveys, finding out if people are actually married or not. And if you're curious, like, okay, my client is married, but they tell me they've got all the paperwork so that the spouse doesn't have to sign, just run it by a real estate attorney. That's what we're here for. Just to make sure that you're good and that you're not going to have some sort of issue when you get under contract. I mean, couldn't tell you how many of those I've looked at to say, oh yeah, that one passes, or this one doesn't have the language, etc. And, just even if it's bad news, just be open with your client, even if it's not the thing they wanted to hear. So that would be better than, than getting under contract and having one of these comes up and then you don't have a choice but to tell them. So what happens in a partition action? So I kind of mentioned that this is when a judge intervenes and says, you guys can't agree, but I'm going to make you agree. In the scenario that I was thinking of, or that we'd seen, where we've got these heirs and some of them want to sell and some of them don't. The ones that want to sell can, file a petition with the court. It is technically a lawsuit. Anytime you open up a case with the court, it's a lawsuit. But it's more in the nature of trying to get the transaction to move forward. It's not necessarily an allegation of wrongdoing where you're trying to get somebody to pay you for their wrongdoing. This is more of like, hey, get us on the same page. So that action will be filed with the court. There is usually, why can't I think of the term? There is a person appointed to, kind of market the property. Receiver, I don't believe is the right word. It's like escaping me right now. But there is a person appointed to kind of quarterback this whole thing. It's usually an attorney or a real estate agent that will get the property on the market, will make sure that kind of title is going to be clear, property is going to be appraised, and they'll try for, you can try to market it for private sale, but if you don't get to a point where you're getting legitimate offers like in line with the appraised value in a private sale, the judge can order it to go to auction. That's kind of the last resort. They would much rather it kind of get everybody on the same page through private sale and try to get the most money possible for the property so that the heirs can have more money. The cost of the court action are going to come out of the proceeds of the sale. Most of the time, the attorney's fees are going to come out of the sale. And then that person that's appointed as quarterback, for lack of a better term, they usually get paid out of the sale too. So, there's a lot of people that are going to have their hands in it once you get to that point. But the court can then, maybe it's trustee. I don't know why it's not coming to me as many as we've seen this year. But then that property will be conveyed by the quarterback. So, the judge says, all right, this is who we're putting in charge. Even if we've got the one that's refusing to sign, too bad. This is what I'm saying the value is. I'm approving that contract, or we're sending it to auction, and the highest bidder, will get the property, and, it'll be conveyed by this special deed by the quarterback, and regardless. Yes, commissioner, that's right. Commissioner is the word. The commissioner, so you'll have a commissioner's deed. Thank you for that. It just would not enter my brain. So, the commissioner's deed. So even if the people don't want to sell it, too bad, the commissioner's deed will be sufficient to convey the title. Oh, hi, James. Form 220. Y'all go look it up. Working in the mountains, we have a lot of issues with GIS and property lines being off from meets and bounds. Yes. Is that a common problem near Lake Norman too? Yes. I always tell, and this is our systems here have the disclaimer when you sign in, this is informational only. Don't rely on this, because the GIS lines, it's not the actual meets and bounds. We've seen, where the lines on GIS will look like they're going right through the house, but if you do the survey, it's not that. But, they're, for the most part, pretty close in Iredell County, but there are parts of the county where if you look at certain subdivisions, like the lines on GIS are very shifted from what the plat actually is. So yeah, we have that too. And yeah, don't forget, you can keep putting in questions. How does that work if a seller or heir is in jail? Oh, hi, Christopher. Are they allowed to sign legal docs without an ID? So yes, because there is a process for identification. Like in North Carolina, our notary statutes allow us under certain procedures to notarize documents, even if a person can't produce a physical, photo ID or government issued photo ID, or like say their government issued photo ID is expired. So, it's kind of convoluted. The notary has to personally know two people who personally know the signer. That's one of the ways, but there are a couple other ways around it. But yes, they are allowed to sign legal documents provided the notary can have use one of those alternative procedures to notarize the documents.
You should give a shout out and tell people.
Oh yeah. So if you guys don't know, go look up Magnify on YouTube, like insane amount of subscribers, over 1 million, and really interesting. For a nerd like me, he takes really interesting concepts but makes them entertaining so that even if you aren't nerdy, you get something out of it, like on all types of subjects. If you ever want to look up Ironland in North Carolina, he is the reason that exists. But I would highly encourage you to go look at his YouTube channel. You will definitely learn something and you'll be entertained in the process. If there is a prescriptive easement in place, where would you find the legal reference for this? Would it be recorded in the Register of Deeds? Yes, it would be. A prescriptive easement has to be ordered by a court. So it existing, the elements for it being met are not enough. I mean, say it's been there 20 years, it meets all of the other requirements. Great, you still have to go get that ordered from a judge. It's quiet title action. So to say, yeah, you have the right to this. And so that order would then be recorded in the Register of Deeds. And then sometimes with that order, there may be some sort of deed or boundary line agreement or encroachment agreement ordered to be recorded as well. But if the order itself contains all of the information in being recorded in the Register of Deeds, that's usually all you'll get. What should a seller be most aware of when considering selling their home subject to, besides the buyer not paying the mortgage? The fact that it stays on your credit, so that if you need to go buy something else, if your debt to income ratios are not where they need to be, you're not going to be able to get another loan. The buyer not paying the mortgage obviously is the biggest one, but the inability to get new credit, not just home loans, but any type of credit, they're going to be looking at your debt to income to see what your rates are, if you can even borrow. We've had people that we know that have not subject to, but they had gotten divorced in another state, and when they got divorced, they stayed on the loan even though they came off of the house. So when they tried to buy a property in North Carolina with their new spouse, they couldn't qualify for the mortgage because they were still on the other one, and the ex-spouse wouldn't refinance off of it. And then you're still on the hook for, say a title defect is, created. Your lender could call the note because of that, which, if they don't own the property, then what exactly is marital interest? Okay, this is a little bit of a deep dive. I alluded to it at the beginning, which it's not a property interest. It doesn't mean you're the owner of the property, but there are these things called inchoate interests, which, forget the word inchoate, just replace it with unrealized or, still to come. And it's the right to share in your spouse's estate, which you can't do until your spouse has passed, and you can't really disinherit your spouse either. So your spouse will have a right to claim, a life estate and property that you own, the elective share, so that they can get a certain amount of money from the estate, as part of the probate process. So those things are still lingering out there until you pass away. So if that exists, unless you give up your right to share in your spouse's estate as to that piece of property. So that's why the specific language is required, because if you give up a property interest, okay, great, you still haven't given up your right to share in the spouse's estate. And you can do it specific to certain properties. It doesn't mean I don't want anything from my spouse's estate, but it could be I'm giving up any claim I have to anything to do with this property. So yeah, inchoate interest, meaning not fully realized yet. And it's not ownership in property. It is the ability to claw back at the property or the money made from that property, so on and so forth, because you are able to take a share of your spouse's estate. It's convoluted and complicated, but it does in fact exist, and it's probably not going anywhere in North Carolina for a long time. Okay. Now, I did want to talk about, like, you know, the question about prescriptive easements and how you get it. Okay. After the NAR settlement, if the seller is offering 3% to a buyer's agent, but the buyer and their agent agreed on a 2.5% fee, is the buyer allowed to collect the 0.5% difference? Let me think that one through. I mean, I guess in the form of a seller credit, but not just as, let me think that through, because, you know, the buyer's agent can't get it unless the buyer agency agreement is altered to allow for that. And I believe that would be, you know, if the seller's giving it no matter what or willing to give it, then it would go to the buyer in the form of a seller credit for that amount. Or, you know, probably wouldn't do a reduction in purchase price, but I guess technically you could. It'd probably be better done as a seller credit. If there is an encroachment, can't you just claim adverse possession? So adverse possession and prescriptive easements are kind of in the same vein. Adverse possession, the outcome is you own the property that you're claiming. And prescriptive easement is just that, an easement. You get the right to have an easement to that, which an easement is a non-possessory right to use someone else's land, not to own it. So, you know, if you got people that are really wary of easements, it's because they think that means you're giving up ownership, but they're not. You know, a claim of adverse possession doesn't mean you'll be successful. Adverse possession and prescriptive easements both are very hard to prove in North Carolina, because, you know, North Carolina it values property ownership and doesn't want it to just be given away through some loopholes. So one of the ways to get adverse possession or a prescriptive easement is that you have to be doing the use, you know, the whatever it was, the fence over the line, or, you know, using the land without permission. So that's the threshold. It has to be without permission. And in North Carolina, permission is presumed so that people don't just immediately off the bat clear off one of those elements to prove adverse possession. So yeah, permission is presumed. You can overcome that presumption by, you know, if you go and say you're not allowed to do that, obviously, you know, it's clear that permission is no longer given. But from right off the bat, North Carolina presumes that, oh, the neighbors got their fence on my property. We're gonna just assume that you gave them permission to do that, and in the law's eyes, that's a good thing, because it doesn't start the clock running for adverse possession or a prescriptive easement. You can revoke that permission at any time, but just know if all these other elements are met, you might start a clock running for them to try to claim something against you. From my super awesome husband, Ryan, who makes literally all of this happen. If there are CC&Rs in place, who enforces them and what happens if you don't follow them? It depends on if there is an HOA or not. So if there is an HOA, typically the HOA, through the board, with help from the management company, if there is one, enforces the CC&Rs. So, you know, if you've got the HOA in place, then usually the CC&Rs and or bylaws together will talk about, all right, if you're not following the landscaping, then it's this much fine. If you're not following, you know, if you didn't get something improved by architectural control, it's this much fine, or you have to remove this, whatever you did that you weren't supposed to do. So that is a little bit more straightforward, because you've got basically a manual of, this is what we're going to do to you if you don't listen to us, and this is how much we're going to charge you for it. Now, if you get charged and you don't pay, then the HOA could put a lien on your house and foreclose against that lien to recover the money. So yes, they do have the right to foreclose in a lot of cases. Now, if there's not an HOA, Yes, you can have restrictions and no HOA. We get that a lot of like, we'll talk to people about, hey, are you trying to have any like exotic pets? Are you trying to use this for residential use? And they'll say, no, but like, why does it matter? I don't have any restrictions. Probably not true. Most properties have restrictions. It's really rare at this point in land development, et cetera, that you don't. But you can have restrictions without having an HOA. So in that case, well, who's going to come after me for it? Whoever else is also subject to those same restrictions, and or the person or their heirs or assigns who created the restrictions. So if you have a declarant that sets up a neighborhood and like, we're not going to do an HOA, but I do want to make sure it's residential use only. I don't want the lots getting subdivided too small, etc. And you do one of those things that you're not supposed to do, the declarant can sue to enforce. So yes, it does require a lawsuit if you can't work it out, but they could sue you to enforce whatever that restriction is. Meaning, if you're trying to run a business, you got to move the business out. Or if you subdivided your land too small, then make you put it back together. So that's one. Or, whoever else is also subject to those same restrictions. So in that case, it would be your neighbors. So your neighbors could sue to enforce the restriction. We'll see sometimes where people are like, these are super old restrictions, nobody's really following them. Well, then your risk that a neighbor will enforce you violating is really low. So, it's a risk evaluation there. Doesn't mean there's not the legal right to do it, but if everybody is violating it the exact same way, probably less likely that someone's going to sue you because you're doing the same thing. If the CC&Rs stipulate that they run for 25 or 30 years and there's an active HOA and board of directors, the CC&Rs need to be revised, updated, and something done at the county, such as an extension or new recording. If that does not, Gail, if there's no renewal, yes. But a lot of these will say, hey, the initial term is 25 years, and then it'll renew for successive periods of 10 years unless there's a writing by all the, everybody that needs to sign, changing them or terminating them. But in the absence of an automatic renewal like that, yes, if they're not extended and recorded at the Register of Deeds, then they will lapse. So, yeah, there probably needs to be something done unless you've got those successive renewals that haven't been terminated or anything.
See if there are any more questions.
All right.
I don't have any, but ask them if they got them.
Yeah, anybody have any more questions?
And it doesn't have to be.
And it doesn't necessarily have to be like the exact things we talked about. If there's other stuff on your mind, if I'm able to answer it, I will. Or anything. Ask me anything. Isn't that what they do on Reddit? Ask me anything. These are some good questions, too.
Tell people your favorite podcast that you're listening to.
My favorite podcast that I'm listening to right now. Money Wise is Sam Parr. I'm looking at Ryan because he's the one that got me onto it. I like Ramit Sethi, Money for Couples, New Heights, and We Are Lake Norman. I almost said Welcome Home Lake Norman, the old title. But Ryan is doing the We Are Lake Norman podcast. It's been revived, but he interviews local business owners, and it's just really fun to hear the stories of the people that own businesses and run them in Lake Norman. And he gives them some pretty silly marketing ideas and some real ones too.
Your favorite event or thing that you've done within the business this year?
Oh, favorite event or thing that we've done within the business this year. Oh, Headshots and Coffee. That's fun. We've done that twice. And it's nice just to have, we'll get a coffee truck out and, anybody can come and get an updated headshot, and we get to talk and chat. Please explain briefly the new compensation situation for real estate folks since this is Supreme Court ruling. Let me make sure I am following. Are we talking about the NAR settlement, or is it something else? Because if it's something else, I may not be 100% up to speed. I'll give you a chance to type in the chat to make sure I'm following. I don't want to answer it incorrectly. James, what are your thoughts on whether or not an offer of compensation should be considered a material fact? Well, it goes back to what is material. If material means the deal wouldn't be done without that knowledge, then I think it could be. If there is a buyer who just cannot afford to pay a buyer agent compensation and they have given strict instructions that they only want to see properties where compensations are being offered, then I think that makes it material. I don't know that in all cases it is, but I think there are cases where it can be considered a material fact.
Yes, just regular NAR.
Oh, yes.
So, layman's terms, NAR settlement.
Yeah, so
I would assume he's not a lawyer.
Yeah.
Or a real estate agent.
yeah, basically the ruling. And I will say in North Carolina, we already had the structure for this, but having to have buyer agency in place before showing a property on behalf of a buyer, this was one thing that listing agents were really concerned about. Like, oh, if I have an open house, I have to have an agency agreement. No, it's working on behalf of a buyer to show the property. Offers of compensation can't be listed in MLS. And then there are other things that, if you are, you can't list in MLS, but if you have your own website and, you're marketing the property on your own website independent of MLS, then you can, you can have that on your own website, but you can't put the link in MLS. You can't link directly to a page that is showing an offer of compensation. So that you got to be kind of careful about that of if you're putting links in, you're not supposed to be using code words or anything. But, the biggest change I think in North Carolina was that you cannot use MLS to make offers of compensation or make them known. Otherwise, we already had buyer agency. We did have some things change on the listing side of when you're entering into, is the compensation going to be paid by the seller, and you decide on a case-by-case basis if you're going to offer it, or continue doing it the old way of seller, the seller will pay 5%, and, you can split that half and half with the buyer agent. We can still do that, but it has to be, just clearly understood up front. But now it's a little bit, more open, and sellers are more wise to, because of the media, et cetera, that they may want to consider negotiating it on a case-by-case basis, and our forms have changed to make that easier to accomplish as well. We still can't put anything about compensation within an offer to purchase. So I actually think that might change just because of, the lawsuit. Oh, thanks.
Let's see if they got anything else.
Yeah.
I'll think of something too. What are your 2025 quick thoughts on the real estate industry as a whole? Like, do you have any just quick,
Oh, he always gets me with this. Like, oh, what are your projections for 2025? And I'm more of a,
not a project, just
or
hey,
like
going
your
into
thoughts.
the new year, you're a
Yeah.
real estate lawyer, you see a lot of real estate happening, just where do you see, trends, I guess?
Yeah. Well, I do think it's kind of interesting as an attorney, because we work with so many different counties and different agents, that the activity in December hasn't been quite as slow as I thought it would be, which is great, and knock on wood, it continues. So hopefully that is a good sign for, the January, which is usually also kind of slow for attorneys. But I've talked to several appraisers who are the busiest they've been in 18 months. So I think that is also a good sign for the market, in that I think maybe people have gotten used to now the fact that the rates are just not going to be 2.5% or 3%. It's, of course, we'd be thrilled if the rates came down a little bit, but hopefully that is a sign that the rates aren't holding people back as much as they were. Got a new question? Oh, this is a good one. If a town road, thank you, Carson, was drawn on an original town survey, but the road was never built, can it be accessed by the public? Could a landowner who owns vacant lot on that proposed road make the town build it? So, so if it's drawn on the survey, some of that has to do with, does the language include dedication to the public for public use? Because even if the road wasn't built, if that particular area was dedicated to public use, then it's for public use. Now, it gets a little more complicated for, if it was not actually dedicated for public use, but it was planned ahead for, we intend to open that street in the future. Because then you're going to have to go through the, the municipal code to see their procedures. It's very specific from town to town and county to county. And whether the landowner could, make the town build the road kind of has to do with, what did the town promise they would do at the beginning? Did they, you could end up looking through meeting minutes from, hearings when this was all done to see what the town committed to doing. That is very difficult, though, because usually, you'll be running up against statute of limitations stuff. Most of the time, if you're within the statute of limitations and a town's going to build a road, then they're that train's left the tracks. So if you get to a point where a road was platted and not built, then you might be out of time for that. I'm not saying it's a never, but it's very difficult. That was a good one, though.
I got a question from one of our recent videos, the video that went out yesterday. Question on here. When the guest said you don't have to go through probate, but you should, what is the downside of not going through probate?
Mm-hmm. So what was our video? What was that video?
How does probate work if there's no will?
Okay. How does probate work if there's no will? So that was probably with Layla we were talking about, or maybe Megan.
Erica?
It was with one of our attorneys. Yeah. So I think, it might have been Erica. So we were talking about sometimes you don't have to go through probate, but there could be cases for why you should. And that would be if you want to convey real property. The North Carolina statutes are really clear that you can't convey to a purchaser for value without probate. So if you elect not to go through probate, basically if you don't care that it's just staying in the family forever and ever, amen, until someone eventually goes through probate, that's fine. But if you are trying to convey property to a purchaser for value, you can't do it without going through probate.
Last call.
Last call, yeah.
Questions?
And thanks for joining in. We didn't decide to do this last minute, but not as in advance as we normally do. So I really appreciate people signing on and participating. Where can I email you future questions and or potential topics to cover? Probably the easiest way to do that is info@Thomas & Weber, because we got a team to gather all of it. So I think that would be the simplest way. info@thomasandweber.com, or we accept them by social media, YouTube, Instagram.
Instagram probably the easiest.
Yeah, Ryan is all up in the Instagram, so he collects questions for this stuff too by Instagram. So however you want to get it to us, there's no wrong way.
Ask if they like the live format.
How did live format okay with you guys? Should we keep doing it? Monthly? How often? Would love to hear from you. Since you took the time to join today, would love to know if we should do this again and how often.
I just said thanks.
Oh, thank you. Thanks for joining. Yeah, and everybody have happy holidays. Whether you celebrate anything or not, just hopefully you have some time to relax and recharge. Bi-weekly or monthly? Yeah, that's doable, I think.
Yeah, for sure, monthly.
Yeah, monthly is definitely doable. Bi-weekly, I think we could probably do that. Yeah, we've been jokingly calling this office hours. So maybe we'll just make it a recurring office hours. Anytime you have enough content to share. Gail, in this industry, that's almost every day. All the stuff that we encounter. But I think we could probably do it twice a month. At least to keep it interesting and not too repetitive. Oh, thanks, Amy. I appreciate it. Well, I think that wraps it up. I just am so appreciative that you guys took the time to join, and we'll keep doing it, and we'll let you know when the next one is. But again, Tiffany Weber with Thomas and Weber. Oh yeah, he'll put up
your stuff.
how you find us on the internet. So we've got our three
I'll get you away.
our three offices on around the lake here in Lake Norman, so Mooresville, Huntersville, Denver. We've got real estate show, we've got the podcast, we've got the YouTube channel, and I also do a ton of like live event speaking. So those are how you can find me. But thanks again, and we'll catch you on the next one.